Hello everyone and welcome to today's 1800RESPECT webcast, Inclusive Service Delivery, an overview of practice guidelines in the family violence sector by the Victorian Equal Opportunity and Human Rights Commission. Thank you for joining us. We'd like to acknowledge the traditional owners and custodians of the land from which we're presenting today, the people of the Kulin Nation, and pay our respects to their elders both past and present. 1800RESPECT is the national sexual assault, domestic family violence, counselling, information and support service, available for anyone impacted by sexual assault, domestic or family violence, including frontline workers seeking information or support. 1800RESPECT is pleased to partner with the Victorian Equal Opportunity and Human Rights Commission on this webcast to provide an overview of the recently released guidelines for family violence services and accommodation, complying with the Equal Opportunity Act 2010, developed as a result of a recommendation made by the Victorian Royal Commission into Family Violence. Please note that this webcast is live and interactive, and we will try to answer as many of your questions at the end of the presentation as possible. We're now pleased to welcome our presenters from the Victorian Equal Opportunity and Human Rights Commission, Julian Albin and Lauren Matthews. Hello to you both and welcome here today. Julian holds qualifications in Law and Arts from the University of Western Australia and is admitted to practice as a solicitor of the Supreme Court of Victoria. In his role as Senior Advisor with the Commission, Julian is responsible for research on projects that seek to advance the objectives of Victoria's anti-discrimination laws by identifying and addressing systemic causes of discrimination. Lauren is a solicitor and educator who has worked in various social justice jurisdictions within Australia, including human rights law, discrimination, refugee, family, child protection, family violence and criminal law. In her capacity as Manager Education Partnerships, Lauren works on the Commission's education and cultural change programs under the Victorian Charter of Human Rights and Responsibilities Act and the Equal Opportunity Act. A very warm welcome to you both. It's my pleasure to hand over to Julian now to get things started.
Great, thanks very much, Catherine. I'd also like to acknowledge the traditional owners of the land we are presenting from today, the people of the Kulin Nation, and pay my respects to elders past and present. So today, as an overview of what I'll be speaking about, I'm going to focus on the background and context for the preparation of the guideline from the Victorian Equal Opportunity and Human Rights Commission. I'm going to talk about our process of preparing that guideline, the background to why we were required to do it, and then share some observations about the consultations that we undertook and what we heard during those consultations to inform the content in the guideline.
And then in the second half of this afternoon, I'll be speaking to the guideline itself. First of all, talking about understanding the law that relates to the guideline, that underpins the guideline. And then secondly, to look at inclusive service delivery, which is a discussion about best practices in service delivery.
Great. Okay, so to kick off with some background. So, as people will be aware, a Victorian Royal Commission into Family Violence was established in February 2015 and delivered its report in March 2016. The Royal Commission's terms of reference included the identification of effective ways to prevent family violence, improve early intervention, support victims, and develop and refine systemic approaches to family violence. Volume 5 of the Royal Commission's report had a specific focus on examining the experiences of diverse communities affected by family violence, including seniors, Aboriginal and Torres Strait Islander communities, lesbian, gay, bisexual, trans and intersex LGBTI communities, and people with disabilities. The Royal Commission's report found, in Volume 5, found that family violence can affect diverse groups in different ways, and that service providers are not necessarily equipped all the time to respond to these experiences and avoid unlawful discrimination in the area of service delivery. Some particular barriers identified in Volume 5 of the Commission's report included, for example, for Aboriginal and Torres Strait Islander communities, the effects of dispossession of land and traditional culture and trauma associated with policies of removal, assimilation and segregation relating, for example, to the stolen generations, as well as the apprehension and reluctance many Aboriginal people have in seeking assistance from government agencies and the racism and lack of understanding that some people might experience when they do seek to access those agencies. For older people, Volume 5 described barriers associated with a lack of understanding from some services of the dynamics of elder abuse as a form of family violence, as well as older people themselves not necessarily recognising their own experiences as constituting a form of family violence that they might seek assistance in relation to. For LGBTI communities, the report talked about the need to recognise particular forms of family violence in those communities, which can include threatening to out people or using homophobia as a tool of control, and fear of discrimination from services based on their sexual orientation or gender identity, including from faith-based service providers who may seek to rely on Equal Opportunity Act exceptions to discriminate. And this is something that Lauren will reflect on when she speaks about the law, is the operation of exceptions and exemptions in the Act. And Lauren will also reflect on our messaging in the guideline about inclusiveness and how just because these exceptions exist doesn't mean people need to apply them. The report also noted mistrust and lack of appropriate services for LGBTI communities as a barrier. This lack of appropriate services for these communities, or for LGBTI communities, for example, was stressed in the Commission, the Victorian Equal Opportunity and Human Rights Commission's own consultations to develop the Equal Opportunity Act practice guideline that we're talking about today. We use this information to focus on how organisations can work closely with other services for referrals when needed and for providing tailored support. The Royal Commission's report also acknowledged intersectionality and stressed that many factors combine to create an individual's identity and experience, and acknowledged the complexity and importance of avoiding categorising people by simply referring to one aspect of their identity. During our own consultations, we heard about some of these interacting experiences in some really interesting and unique ways. For example, specific issues for LGBTI older people were raised in our consultations that informed the content of our guideline. And on intersectionality, Lauren has some reflections on the particular challenges for us in dealing with Equal Opportunity Act attribute groups and how we account for intersectionality in describing our laws.
In the guideline, we make it clear that there are a lot of overlapping personal characteristics that can lead to a distinct experience of family violence. The Equal Opportunity Act has a number of attributes or characteristics that people can experience: age, breastfeeding, employment activity, gender identity, disability, marital status, all in. There are 18 different characteristics. So what we understand is that there can be an overlap between these, between marital status and disability, gender identity and physical features or race, and that the overlapping between these experiences has a distinct outcome for those people. This isn't to diminish having one characteristic, but it recognises that there can be many factors that make it difficult for people with a particular experience or particular backgrounds to access supports and infrastructure that they require. People with diverse backgrounds are also at greater risk of family violence. They experience it at higher rates, and so this puts an emphasis on inclusive and non-discriminatory services.
I won't go into too much more detail on Volume 5 of the Royal Commission's report and its findings more generally. People may be familiar with the report or not, but I suggest we've certainly found it a really helpful educative piece, just looking at Volume 5, which describes these intersecting characteristics and particular experiences in a lot of detail. One of the challenges for us in developing the guideline was to consider how much information we would or wouldn't duplicate, given the issues were described so well in Volume 5 itself. So I'd encourage people to look at Volume 5 for some further insight into the issue of family violence and diversity, our experiences for diverse communities. So to get to our work and our task of the guideline, the report, Volume 5 of the report, made a recommendation directly to us at the Victorian Equal Opportunity and Human Rights Commission, Recommendation 141. And that recommendation was to and I'll state it, issue a guideline under Section 148 of the Equal Opportunity Act to guide service providers in meeting their obligation to act inclusively and avoid discrimination when delivering services to all people who are affected by family violence. The guidelines should apply to family violence service providers, including men's behaviour change programs, as well as to universal and mainstream organisations. So it was very broad, the terms of the recommendation. It was a challenge for us to think about how we would tailor the information to those different services, mindful as well of the sort of mainstream versus specialist response and so on. So we wanted to adapt our messaging to make sure it reflected a broad experience for the range of audiences that recommendation was directed to. So I'll speak now about who we consulted, our time frame and some of the questions we asked, so reflecting on the process of developing this practice guideline. So as I noted, the recommendation, the terms of it were quite broad. So we consulted very widely to get a broad perspective. We consulted with a total of 55 organisations within a reasonably short time frame. We commenced with a period of research before we consulted, so we gathered what we could from the Royal Commission's report itself and from Volume 5. And from the various submissions that were made to the Royal Commission. So we had an initial period of research that was very to help inform how we'd approach our actual consultations. We knew though that we needed to hear more about these experiences and gather information about current needs and levels of understanding from the services who would be the target audience for the guideline. So we needed fresh information about the issues and about what services actually needed in terms of this product. The terms of the Equal Opportunity Act, Section 148, which gives us the power to issue guidelines like this, also provides that we're required to consult with the people to whom the guidelines relate. The consultations occurred gradually. We commenced by speaking with advocacy and peak agencies, really, to hear more about issues, so the issues identification stage. So in Victoria, that included organisations such as Seniors Rights Victoria, the Victorian Gay and Lesbian Rights Lobby, Victorian Aboriginal Legal Service, so to hear more about the issues for the diverse communities described in Volume 5 from those organisations and their perspective on barriers in service delivery. In the later stages, we engaged directly with the services themselves, service and accommodation providers, both general and specialist, as well as men's behaviour change programs, as required by the recommendation. And that was really useful for us to get those perspectives. We asked a range of questions. When we spoke to service providers, we focused on their current levels of understanding of experiences of family violence for diverse communities, as well as their current understanding of anti-discrimination laws, because the guideline was seeking to describe these laws for people, and how these apply to service delivery for these communities. We also looked at how services are currently responding to these communities, what lessons we could gather, what are people doing well, what are the best practice examples, what are the challenges, and what are the challenges that they're facing to inform our content. We wanted the guideline to have a very practical focus, and we wanted to make sure we had that insight so that we were addressing the needs of the services who were the targets audiences for the guideline. The queries and suggestions were invaluable, and they're reflected throughout the guideline in the practical tips and case studies in it. We wanted to make it clear, really, that we understood that perspective. We know that no service, particularly services that are dedicating their time to supporting people experiencing family violence, would set out to deliberately or intentionally discriminate against people. We know that these issues, though, can be complex, and when you couple them with services and workplace environments that are often working at capacity and with clients in crisis, issues can arise, and it's a real challenge to be giving this sort of extra layer of guidance when people are facing those genuine constraints and challenges. So this is why we wanted the resource to be closely informed by the perspective of services. And we wanted a document that went beyond just legal compliance to include practical guidance and case studies on how services can be proactive in preventing discrimination from occurring. And Lauren will speak to this in her descriptions of the positive duty that we have in Victoria's Equal Opportunity Act, which gives us an anchor to be able to describe the range of ways, and it's a legal obligation, but gives us opportunity to talk about how people can proactively prevent discrimination from occurring in the first place. So as I've suggested, the consultations were very valuable in terms of complementing what we could gather from the Royal Commission's report. But we heard some really useful specific information and examples that help to inform the tips in the guideline. Lauren will speak more about some of the principles of non-discriminatory and inclusive service delivery to different communities. I'm going to note just a few quick examples now of relating to service delivery to LGBTI communities. So we heard examples of intersecting experiences and forms of family violence for LGBTI communities. This included descriptions from organisations working with older people and LGBTI communities, which I touched on earlier, I think. We heard about, for example, adult children not acknowledging the same-sex relationship or gender identity of their parents. And for younger people, we heard about the risk of homelessness because of abuse and rejection from families based on sexual orientation or gender identity as forms of family violence. We also heard some specific information about service barriers. For example, for LGBTI communities, we heard about barriers that might prevent transgender and gender diverse people from accessing services, which informed some of the practical tips in the guideline. Some of those tips include not making assumptions, for example, about a voice over the phone, so gendering of people, not using sir and so on, and making assumptions based on what you're hearing on the phone. And also, you know, in internet material, websites or in intake forms, for example, making sure that forms account for more than just male and female identities and go beyond that binary. This is really crucial for people. It can seem like a simple thing or even just an administrative matter, but it's we know that it's a serious denial of a person's identity. It will deter people from accessing services when they see that they're essentially not welcome and not being acknowledged if they're not in a form and can't identify themselves. We gathered a lot about specific information needs. For example, Service wanted to know about the operation of relevant Equal Opportunity Act exceptions and their implications. For example, with regard to transgender women accessing women-only services, and this is something Lauren will reflect on in the description of the exceptions in the law that are tricky on that subject in some respects. The guideline, there's one useful example in the guideline I'll mention briefly that I think is a positive example of the suggestions we make about policy and practice change that organisations can engage in. We were fortunate to consult with the Women's Information Referral Exchange, WIRE, and to get permission from WIRE to include a case study on their response to the issue of trans women accessing services. So it's on page 21 of the guideline, and perhaps I won't go into too much detail, but I'd encourage people to look at that as a great practice example. WIRE became aware that some trans women were accessing their services because they were being excluded from others. So they wanted to set themselves up as exemplars in terms of their inclusiveness for trans women, and they set about a proactive agenda of doing that. So the case study notes that WIRE updated its policy about gender inclusion to make it clear that all people who self-identify or express their gender as a woman or girl or a gender non-conforming are eligible to use their service. They conveyed this broadly to staff and also developed ongoing relationships with LGBTI service providers and advocates to inform their own practice. So as a result, WIRE has seen improvements in their service and more women, and including trans women, accessing their service. So there's really positive examples in the guideline along those lines that people can look to. I think one quick principle I can talk about that was very useful is the idea of referrals and working with specialist agencies to get capacity to understand issues, particularly when you're dealing with some of the constraints and challenges that we were talking about. So in a number of respects, and that WIRE case study is an example of looking to other organisations who do have specialist expertise and do have the capacity to provide referrals on and so on. So there's principles there about working closely with other organisations. Another example relates to providing services for Aboriginal and Torres Strait Islander communities. So the guideline notes that mainstream services should develop working and sustainable relationships with local Aboriginal and Torres Strait Islander communities, including with local elders and respected people, and working in partnership with Aboriginal and Torres Strait Islander controlled organisations. So that's it from me for now. I'll hand over to Lauren now to speak more about the content of the guideline and starting with a description of the law.
Thanks, Julian. In understanding the law, I'd like to imagine that we had three cogs in front of us, because understanding the law can be a bit of a tricky thing, but in order to avoid discrimination, it's really important to try to have an understanding of this. So if we could imagine three cogs that they need each other to operate. One cog I'm going to call an area of activity. Another cog is attributes, and another cog is conduct that can amount to direct or indirect discrimination. We need to put all three cogs together for any conduct or anything to amount to discrimination. So you can't have discrimination unless it's an area of activity. And there are many different areas of activity, but I'm going to talk about this cog first. So in order to have discrimination, we must be talking about an area of public life. And the guideline discusses two areas of activity. One, the provision of goods and services, and the other, accommodation providers. Now, it's important to look at these as the sectors that are captured and caught by the Equal Opportunity Act and discrimination law. So taking the first one, the area of activity being the provision of goods and services. So anybody that is providing goods and services must not discriminate. To work out if family violence service providers are providing a service, we can say the guideline concludes that it's likely that family violence service providers would certainly fall within the definition of providing a service. That would include family violence, crisis response, intake and recovery organisations, medical clinics, health, age, disability, counselling services. All of those would be captured by the definition of providing a goods and services. So anybody providing goods and services must not discriminate in some key ways. They must not discriminate when they're providing those services. Secondly, the terms on which those goods and services are offered to people. And thirdly, by subjecting certain people to harm in connection with accessing those services. So it's quite important to understand those elements. Another area of activity is in the area of offering accommodation to people. People must not discriminate when they're providing accommodation or offering to provide accommodation. So the first one is in offering to provide accommodation by refusing or failing to accept a person's application, by the way in which the person's application is processed, or the terms in which the accommodation is offered to another person. So that's in offering accommodation, and the second part is in actually providing the accommodation. There cannot be discrimination in varying the terms in which accommodation is provided to the person, or denying or limiting access, or by evicting a person from accommodation, refusing to extend or renew the accommodation, etc. So there are a whole number of ways that there cannot be discrimination. But like I said a moment ago, those areas of activities that there can't be discrimination must only relate to where there is people of a particular attribute. So discrimination will always be where a person is of a particular attribute. And I mentioned those earlier, and relevant to the guideline is in the area of sex, gender identity, race, religious belief or activity, age, disability, sexual orientation, lawful sexual activity, or personal association. Now, they are some of the common attributes that arise in the family violence space. So, and as I said earlier, there can also be intersectionality between those particular attributes or characteristics. So one cog is looking at accommodation, goods and services. The second cog is that there must be the conduct must be because a person is of one of those attributes. If it doesn't fall within those attributes, it's not discrimination. The third cog in the wheel is looking at conduct that is unlawful, that amounts to discrimination. And there can be two types of discrimination. There can be direct discrimination and indirect discrimination. When looking at either one of them, it is still discrimination, even if there's another reason for what somebody is doing, so long as the main reason is the characteristic that somebody is being treated in that way because of one of those attributes. The discrimination can also be by doing something, but also failing to do something. So I'm just going to turn to direct discrimination. And direct discrimination is when somebody is treated unfavourably because of one of those attributes. This can often happen where people make unfair assumptions about what people with a particular characteristic can and cannot do, or about what kinds of services should and shouldn't be accessed. For example, discrimination can occur where there's poor service delivery or refusal to provide a service because a person is of a particular attribute, where there's humiliating treatment because of one of those attributes, or where there's a hostile environment because that person is of one of those attributes. Indirect discrimination is different. Indirect discrimination is where somebody imposes a condition or a requirement or a practice on somebody that disadvantages that person and it's not reasonable. So policies, practice or behaviour that seem to treat all people the same but actually unfairly disadvantage someone with a particular attribute amounts to indirect discrimination. Where somebody has imposed a condition that seems reasonable in all of the circumstances, it will not be against the law if if some people are disadvantaged. For example, rules such as there can be no pets, but presents a problem for people with disabilities who may require pets. Conditions of entry saying that only certain people can enter can create a problem of indirect discrimination. Requiring people at an accommodation facility to cook may be difficult for some people with particular physical characteristics or disability. Requiring people to provide a birth certificate may be difficult for some people, particularly if they are trans or gender diverse. So there are many ways that people can discriminate, direct or indirect, and the three cogs need to work together. To amount to discrimination, there must be an area of activity such as goods, services, provision of accommodation, combined with an attribute, one of the ones listed under the Equal Opportunity Act. There are 18, but I've mentioned some that are particularly relevant for family violence service providers and accommodation providers. And thirdly, there must be conduct that is unlawful, unlawful discrimination by treating somebody unfavourably or imposing a condition, etc. The next, combined, when we're talking about unlawful conduct as well as discrimination, it's also unlawful to fail to make reasonable adjustments with people with disabilities.
That's right. So another useful resource that we have that speaks to this, accompanying the guideline, we also have an educational resource with case studies, a range of case studies. And there's one case study in there dealing with reasonable adjustments. That's very practical. So I'd encourage people to look at that. It relates to speaking to someone about what their needs are, what different ways that you might communicate with them in terms of communication access, and responding to those needs. It might be breaks in a session and so on for somebody, and there can be small ways that adjustments can be made. I should briefly note as well that the principles Lauren and I are talking about, I don't think I made this clear at the outset, we're speaking about the Victorian Equal Opportunity Act, but a lot of these principles have a broader application and are reflected in similar ways in national laws as well, so relevant for a national audience too.
So the law requires people with disabilities to have reasonable adjustments so that they can participate in and access services and to obtain a benefit from the services. And there is a criteria for what is reasonable. The type of with time constraints, I'll let you refer to the guideline itself to look at what reasonable means. But in terms of the type of adjustments that can be offered to people with disabilities, it includes providing services at people's homes, providing accessible car spaces, allowing people extra time in order to fill out questionnaires or intake forms, providing accessible rooms and facilities, providing information in accessible ways, ensuring people have communication support. These are some of the mechanisms to make sure that people with disabilities have reasonable adjustments. I would now like to refer to the issue very briefly of exceptions and exemptions. So while the conduct that we've talked about is discrimination, there are two mechanisms within the Equal Opportunity Act that means that while the conduct is still discrimination, it becomes lawful discrimination. One way is through exceptions. The law provides, the Victorian Equal Opportunity Act provides exceptions to people so that if they come within an exception, they are not discriminating. Sorry, they are discriminating, but the discrimination becomes lawful. The first exception under the law is the welfare exceptions. It's not against the law to provide targeted services for a part of the community where the person is offering specialist services, benefits or facilities that meet the needs of people with a particular attribute. The same applies in the providing accommodation, that accommodation providers can limit eligibility for accommodation wholly or mainly for the welfare of persons with a particular attribute, and in those it's restricted to age, sex, race, religious beliefs. There is also religious exceptions where religious bodies can discriminate against a person on the basis of religious belief or activity, sex, sexual orientation, lawful sexual activity, marital status, parental status, and gender identity. I say those because they're restricted to those particular attributes. The religious exemptions don't apply to all attributes. And this allows, the religious exemption allows for discrimination to conform with the doctrines, beliefs, or principles of the religion. And the discrimination is reasonably necessary to avoid injury to the religious sensitivities of people who follow that religion. I should add that the religious exemptions are rarely used by religious organisations. And I'll just say more generally about exceptions. While these exceptions might be available for service providers, as a matter of best practice, service providers might want to consider not relying on these exceptions. There has to be consideration of the long-lasting impact of excluding people and discrimination. There's also the possibility of exemptions under the Equal Opportunity Act, where people can apply to VCAT for an exemption under any provision of the Equal Opportunity Act for up to 5 years. I would just like to say a final word about the positive duty under the Equal Opportunity Act. The Equal Opportunity Act is very unique in making a special provision that organisations and people must take reasonable and proportional measures to eliminate discrimination, sexual harassment and victimisation as far as possible. The guideline gives a lot of very detailed information about what reasonable and proportionate might mean in order for people to be proactive about eliminating discrimination, looking at developing an equal opportunity policy, ensuring that the policies are communicated within the organisation, reviewing the policy at regular intervals, ensuring clients know about these policies, developing complaints procedures that comply with the Act, and regularly monitoring the service delivery. The guideline has with it a number of specific examples of inclusive services and tips for organisations that I would encourage you to look at. The guideline talks about tips and best practice service delivery to LGBTI people, multicultural community, Aboriginal and Torres Strait Islander people, sex workers, people with disability, and younger and older clients. So I would encourage you to make use of that resource.
Great. Thank you very much for that presentation, Julian and Lauren. Very interesting and informative. We do have a couple of questions which we will get to now. So, services can sometimes struggle to meet the needs of clients due to capacity and other constraints, which is something that you touched on, Julian. How can services still meet the standards and legal obligations described in the guidelines in the face of these challenges?
Well, I think there were some reflections, I think, early on, as you're suggesting, Catherine. The requirements of the law, so when we talk about reasonable adjustments, for example, or the principles of sort of reasonable and proportionate measures, depend on the resources available to people and the scenario that they're facing. So if I think about the reasonable adjustments example for people with disabilities, I think the answer is that there can be some small ways that people can make adjustments, and it might be that they can't meet the full range of needs that somebody has because of resourcing and capacity constraints and so on, but it might just be as simple as allowing somebody more time more breaks in a session, presenting material in plain English, for example, for somebody who might need that kind of material. So I guess the answer is that the response depends to an extent on what the capacity of the organisation is, and there can be some small and practical ways that people can get some sort of quick wins, I guess, and it might be, you know, in a policy sense, to have sort of outward-facing messaging and materials, looking at your website, for example, and so on, and just thinking, is it, if I approach this website and I'm trying to approach this service, what would this be inclusive to the diverse communities we're talking about? So I guess it is a challenge, and I think the answer is that there are discrete ways and smaller ways that organisations might be able to respond.
Lovely, thank you. So can you comment on the applicability of the Victorian Equal Opportunity Act to employment law when a woman escaping family violence is trying to re-enter the workforce and the employer is aware of her circumstances and discriminates on the ground of her circumstances?
Well, I'll just address that briefly. First of all, if somebody is trying to re-enter the workforce, I didn't mention one of the other areas of activity as I was talking about my cogs in the wheel. Another area of activity is in relation to employment, which we weren't specifically looking at today, but employment is an important area of activity. And if somebody is escaping family violence, there needs to be, if they're being discriminated on the grounds of her circumstances, it would need to link to one of the attributes under the Act. And it might be in this, if this fact scenario had more details, it might be on the basis of sex, because family violence differentially affects women, as that was found by the Royal Commission. But it's certainly the case now that there's an increasing move towards family violence leave, for example, and the Victorian Public Service is leading by example in its enterprise bargaining agreement allowing family violence leave. And so this is something that is a changing space. And so certainly with more facts relating to this scenario, it may be a discrimination issue, so long as it did come within those components of the Act.
So just on that, if what happens if somebody makes a complaint of discrimination against somebody?
If somebody makes a complaint of discrimination, a complaint may be dealt with internally by organisations, but externally, a complaint of discrimination can be made to two bodies. First of all, it can be made to us, the Victorian Equal Opportunity and Human Rights Commission, and we have a dispute resolution function where people can enter into a conciliation, which is low cost and quite an effective way to be able to resolve complaints. Another way is to go directly to VCAT, the Victorian Civil and Administrative Appeals Administrative Tribunal, where there will be a public hearing and a binding decision.
Mm-hmm. Great. Now that this is another question that's come through, so now that the guideline has been published, what is the implementation plan and how will that be monitored or supported?
So our initial implementation is essentially involving, so we're sort of fresh off the release of the guideline, the immediate activities have been to promote and distribute widely through at least the range of organisations that we consulted with. So we're making those links. We've done an initial mail out. We're continuing to kind of alert them to the fact of the guideline in that direct sense. We've also had just some initial activity on sort of promotion and alerts, Facebook and sort of social media activities, the regular channels. We're having to give more thought though to what the longer term concrete activities might be, whether they might be sort of specific training or whether it's a way of looking at other organisations that are doing so. In terms of that activity, we're giving more thought to that at the moment, but it's really just about continuing to raise awareness, distribute ourselves if people want copies of the guideline, and they're coming to us just to make people aware of it too. So those are some of the early activities, and we hope to engage in more as we progress.
Great. So there is a couple of questions just on that. So the best place to obtain the copy of the guidelines, I think we have included the link in the resources tab of the presentation that you should be able to see there today, but I gather it is available on the Commission's website. Great.
Together with the education piece that goes with it, which provides a number of case studies which are really informative. We provide the education piece provides a case study, proposes some answers, and answers them.
Great.
So for educators, it's quite useful. I'll just add one more thing about when the Commission issue a guideline. We issue a guideline such as this one under clear functions that we have, a power that we have under the Equal Opportunity Act. And it's important to note that when we issue a guideline like this, while the guideline itself is not legally binding, courts and tribunals can consider the guideline when they're dealing with matters. And so it is something that is quite an important status within the work that we do.
Great. Well, thank you very much for that. We are out of time for any further questions at this point in time, but thank you very much for coming along and joining in this webinar today. If you'd like further information, please visit the 1800RESPECT website, where you can access resources including the 1800 Frontline Workers Toolkit and previous webinars. You can also subscribe to the 1800RESPECT Workers and Professionals newsletter. Just visit the homepage on our website and register via the Stay Informed section at the bottom of the page. A big thank you to everyone for attending and contributing to today's webcast. We'd appreciate you providing your feedback through an online survey, which you will be redirected to now. And thank you in advance for your feedback. And we'd like to wish everybody a very pleasant afternoon, and thank you both for attending today.
Thanks very much for having us.
Thank you.